I'll make a brief 10-minute presentation on what I found in the last 3 months. There's not much work done on the area of judicial reforms and intergovernmental donor agencies. And so what you'll be seeing here actually is in many ways material that has been obtained for the first time. After I speak, Pratiksha Bakshi and Bikramjit Batra, both from the Center for Law and Governance, GNU, will briefly respond for 5 minutes because there are certain aspects over here which I can't touch upon, which they've worked on, so they'll give a better perspective to what I'm saying. The World Bank's focus on judicial reforms is linked to its so-called discovery of rule of law reforms in the early 1990s, and this coincided with the fall of the communist governments both in Eastern Europe and the USSR. And in keeping with the body of theory which we call the new institutional economic theory that underpins to a large extent the bank's work in what they call good governance, the bank sought to translate the rule of law from a philosophical idea into tangible institutions that could be reformed. So now, what the new institutional economic theory explicitly identifies is the rule of law as a factor contributing to economic growth, and also highlights the importance of positive law and legal institutions for protecting property as well as enforcing contracts. So both these are seen as the two most important constituents of the bank's understanding of the rule of law. Between 1990 and 2003, the bank has spent $2.9 billion on around 330 projects around the world in the pursuit of rule of law. Now, if you look at internal World Bank documents, it enumerates various reforms that are needed for actuating the rule of law, and these can broadly be divided into two parts. One is what they call reforming laws, and this would involve drafting substantive laws, often which are categorized into 5 main headings: property, contract, company, bankruptcy, and competition. And the other part, which actually I'll be focusing on, is reforming institutions. And this would include courts, legislative bodies, registries, ombudsmen, etc. And what I'm going to actually look upon very specifically now is the judiciary. Initially, the bank focused primarily on assisting countries through law reform, and this was by helping them develop legal environments that encouraged local and foreign private investment, which included stable and predictable systems to honor and protect property and contractual rights. Now, since then, the bank has begun focusing on judicial reforms as it began to realize that enacting legislation alone could not yield desired reforms without adequate infrastructure to back it up. Subsequently, their focus became building and reforming institutions, both in terms of courts and alternate dispute resolution. If you look at their lending instruments that the bank uses to enforce judicial reform, the most common method is actually to induce changes in legislation and reforms in the administration of justice. So what the bank does is, when it is actually giving a loan to a country, one of the clauses would ask for certain changes in the law. But there are other methods that they also use are, for instance, investment operations for institution building and technical assistance, learning and innovation loans, and adaptable program lending loans. Now, looking more closely at the South Asian situation, in Sri Lanka, the World Bank has a 50 million project which is ongoing, of which 45 million will be financed by the bank. And I just looked at some of the documents on the World Bank website itself, which actually look at the reasons why the bank is giving this loan. And just a closer reading of this will give you an idea of where the bank is coming from. So, for instance, the bank says that it is imperative that the efficiency and productivity of the public sector as well as the private sector businesses is improved in Sri Lanka in order to achieve the high rate of growth and investment levels. In the past decade, the government has already introduced several reform measures in the area of banking, finance, capital markets, governance, taxation, procurement, trade, investment, and dispute resolution towards reducing transaction costs. However, the reform agenda remains unfinished and prevailing economic growth has not been able to adequately reduce poverty and regional disparity in Sri Lanka. Within this broader context, government has outlined plans for institutional policy changes to address the long-term structural changes. So then, if you look at Bangladesh, you look at the World Bank's legal and judicial capacity building project, which is ongoing, which is being implemented by both the Law Ministry and the Supreme Court in Bangladesh. If you look at the aims of the project, it says more efficient and transparent judicial system as a catalyst for ensuring the rule of law and cost-effective dispensation of justice, the introduction of modern commercial laws and dispute resolution mechanism, ensuring the integrity of the financial sector, increasing gender sensitivity. So obviously they're coming from a perspective where the focus is on the financial sector and commercial laws, as opposed to a more general justice reform kind of thing. So now if you look at Pakistan, Pakistan is very interesting because the largest ever reform program in any law and justice sector is actually ongoing in Pakistan. And here, it's not the World Bank, but it's the Asian Development Bank, which also lends a large amount of money in this sector. And the ADB actually has provided $350 million and an additional 20 million technical assistance loan, which is called the Access to Justice Development Fund, which is the largest ever reform program in any law and justice sector so far to date. And the objectives of the Access to Justice program in Pakistan, it's very interesting because one of the clauses in the objectives, it talks about community. And what do they mean by community? That is, the public will benefit from better judicial services being improved by improved efficiency in the administration of justice and speedy disposal of cases. Through this means, it is intended that those who have opted out from the formal justice system, notably the commercial community, will regain confidence to return their disputes for resolution. Additionally, the provision for legal aid will contribute to helping the poor to become aware of their rights. So the poor, I mean, it's almost like it's an afterthought that they are talking about legal aid for the poor, etc. And commercial disputes, obviously, where the focus is. Now, coming to India, so far, the only major project which had directly to do with judicial reforms in India is a project which has not taken off. But I'm going to look at it slightly in detail because it gives us an idea of what actually the ADB wanted to do in India, but for many reasons it hasn't taken off. But I'm going to look at the documents that we've obtained to do with this project to kind of just see where the ADB is coming from as well. Now, the ADB's Administration of Justice project in India, the government of India requested the, can you just go to the next one? Yeah. So the government of India requested the ADB to provide a technical assistance in 2003 for a sectoral and diagnostic study on administration of justice. A technical assistance project on administration of justice was included in the ADB's 2003 country strategy and program for India. And an ADB fact-finding mission visited New Delhi in April and May of 2003, and it was approved on 25th July 2003. Now, on October 20th, 2006, before I go to the details of this, on October 20th, 2006, I'm just quoting from a speech by the Deputy General Counsel of the ADB to also just kind of pinpoint where the ADB is, that the ADB's focus is not very different from the World Bank in terms of judicial reform. And Fisher in the speech actually says, I'm quoting, since 1995, international donors have invested more than $1 billion in legal and judicial reform work for good reason. Strong rule-based institutions promote economic growth. A fair, independent and efficient judiciary supports equitable development. It improves predictability in the market and can increase the per capita income growth rate of a country by 1.9 percentage points. On the other hand, a weak judiciary leads to lower per capita income, higher poverty rates, lower